Okay, so it's now 7:25. We have the video going. We're going to open the meeting with case 884A, which is for a special permit to have an accessory dwelling at 17 Oak Road. If you want to come forward and show us your drawings and explain what you want to accomplish.
All right. These are my parents, Ralph and Caroline Kroll, and they are, I apologize, getting elderly. And we've,
You can
I know.
snack her for that.
So
You can
later.
snack her for that, or you
Later.
can come up too if you'd like.
So this is the proposed plan. What we're going to be, let me get in the middle here. What we're going to be doing, what we're
Yeah,
going to.
we're pretty comfortable here.
Okay. His plan showed the garage going the other way. I have no idea why it came through that way, and I thought, why are we doing
It's
that?
fine. Yeah.
Well,
That's-
actually, it shows the garage coming out this way towards Oak Road.
Correct. That's the way this will go.
Right.
Correct.
There was a previous one that showed it a side entry garage.
So the
one that
addition
was
is off
attached.
of...
Okay, it's not exactly an addition. The house that I'm in now is in very bad repair, and we're going to take the entire house down, and this is coming in.
Okay.
So this is going in the same spot, okay?
Have you considered, since you're building from scratch, have you considered adding a firewall?
Well, let's go through
It's
the
a,
whole.
it's a modular, so.
So there's actually going to be a double wall between them.
Okay.
Okay, so, this is the back view, so that would be the backyard. The side views are pretty much the same, because it just shows the garage is slightly smaller than the house itself. And then, that looks like a very important drawing, and I have no idea what it's for. So this will show, I'm basically going from 3 bedrooms to 3 bedrooms. This door here, as you can see, there's this double wall he was just talking about. Okay, so this door here would go from my living room to my parents' living room. So they have an entrance in the garage, they have an entrance in the front, and then this comes in here. That's about it.
Okay.
So the two houses aren't identical.
No, theirs is 811 square feet, and mine, I believe, is 1,100. So they only have a 1-bedroom apartment unit attached. I don't know what we want to call it.
Yeah.
Well, I don't want to call it an apartment, it's not
Okay.
exactly, you know.
What should we call it?
It's an accessory
It's an,
dwelling.
it's an, it's an,
dwelling.
yeah, it's an
Accessory dwelling.
accessory dwelling. It's an in-law suite.
Is there anything in the bylaws about new construction? I don't even know.
No,
This is for...
let's take a minute to read the special permit section, just so we can all, 87858.
No concerns. 26. Want me to read Roland's?
Roland did submit something.
Yeah.
So, special permit authorizing an accessory dwelling may be granted only if consistent with the following. Either unit shall be occupied only by one or more persons related by blood or marriage or functionally dependent for medical or other reasons on the occupants of the other unit.
Yes, yes, and yes.
The Board of Health must have documented to the special permit granting authority that sewage disposal will be and you have a septic plan.
Oh, yeah, my septic's fine.
2 parking spaces are required for the primary dwelling, 2 additional parking spaces are required for the accessory dwelling. You satisfy that?
Absolutely, one in each and one
Right,
in
exactly.
front.
A certificate of occupancy, this is for your, for a certificate of occupancy for the accessory dwelling shall be issued for a period of no greater than 3 years. So every 3 years, you would then come back to
Reapply or
us. And
something.
it's not a matter of reapplying, it's, well,
Filling out a form.
it's filling out a form,
Oh,
and they
okay,
keep a
all right.
list.
All right.
Termination of occupancy satisfying subsection A if this section or change of ownership shall terminate the special permit and the certificate of occupancy as an accessory dwelling. So if you sell the house, then the person who buys it would have to come before us and reestablish.
Start over,
it.
right. Okay.
So,
I'm not going anywhere, but
Okay.
yeah.
so those are the requirements.
Okay.
Now, you
And you
said,
brought your parents, they're poster children.
when you were talking parking, you said two in front. How far from the garage to the street?
36 feet.
Okay, plenty
Yeah,
of room.
so plenty of room.
They're not asking for any kind of setback.
No,
No, this is
no,
not a
everything is,
variance.
there's no variances at all,
So,
everything is within.
Mark, do you have any comments?
No, just, looks nice.
What's the
Thank
lot
you.
size?
Hopefully you'll need it for a good long time.
How soon are you
It's
gonna get
100
them
feet
down?
from the front to the back,
Yeah.
and then it's 220 feet long,
Okay.
the lot is. So the septic system is actually on this side, and then there's more
Yeah.
room on the other
So
side.
it's not a 40,000 square foot lot, so is there something needed for that?
It's
No.
just over half an acre.
No, it's a
No,
grandfathered lot.
But,
We're
but
not-
there's a dwelling on it already.
Okay, so
Yes.
as long as we
So
don't.
this
yeah.
is, they're replacing the dwelling, which
Yeah.
happens to have an in-law in it, and they are not, there are no setback variances that are required.
No variance is
Even-
needed.
Even if there wasn't a dwelling on the property, because it's a grandfathered lot, and they're not doing any setback variances,
Right.
they wouldn't need to come before us for that. They're only coming for us for the accessory dwelling.
Cheryl, do you have any comments?
No, I would put it to a vote.
Rod?
No.
So, does someone want to make a motion?
Oh, you have to officially
Close the,
appoint Mark.
Actually, that's a good point.
Oh, that's true, I'm not even a voting
Mark
member
is a
yet.
voting alternate on this matter. So first, first we close the hearing, and then we'll deliberate and vote. So,
Okay,
do we have
so
a
I
motion
step
to
back?
close? Thanks. Do we have a motion to close the hearing?
Move to close the hearing.
Okay. Second?
Second?
Are all in favor?
Yes.
Okay, now, are there any deliberations, or would someone like to make a motion on this matter?
I'll make a motion that we grant it's not a special permit for accessory dwelling at 17.
I'm sorry, just a point of order, and it's probably too late, but we didn't ask if there was anybody else in the room who wanted to comment on this, either for or
We should have
against.
asked for butters, although we've been chatting
Yeah.
before the meeting, so I think, unless there were anyone objecting, is everyone satisfied that?
all in
Okay,
favor. We're all in
okay.
favor.
Thank you.
Okay, so we don't have to reopen the,
Were all three of you kids?
No, these are the Oak Road people we.
You're
we
butters?
we-
My across the street neighbor.
Oh, weren't you sweet to come tonight? I make a motion that we grant the special permit for an accessory dwelling at 17 Oak Road pursuant to 173-26, as shown in the plan dated, and Mike, I'm sorry, I don't have my glasses on, I can't see it. Can you see it?
I have to put my glasses up. There's no,
12/8,
October 2nd,
2016.
2000.
October 2nd, 2000.
Well, the plan,
Second 2000, that's the septic.
Oh, okay, wait a minute,
That's the
wait.
septic system.
Here, this one,
yeah,
this one
12/8.
Well, but this doesn't.
that has the wrong garage.
Yeah.
has the wrong
Do you want
garage.
this one?
Sure.
Yes. And then if you could
And then
provide
can
a
we
copy
keep
to
it?
Cheryl, I mean, to Shelley, I mean.
Shelley has everything.
Okay,
Does she
so
have
we
this
just-
one?
She has everything,
Okay.
yeah.
Okay.
That is, the last date is 1/19/2017.
Okay, final
January
revision.
19th, yeah.
All right.
Can I have a vote?
A second?
Second.
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 In broad seconding, and all in favor?
Aye.
Aye.
Aye. Any opposed? Passes. You there'll be a decision if you proceed, if you
Written
proceed
decision will come soon, but you
within
don't
a
have.
couple weeks. If you, if you proceed before that decision, there's some risk.
Yeah, I think there's a 21-day appeal
Right.
period or something.
But essentially, you have your special permit.
So don't build for 21 days.
There's a 21-day
Which was-
appeal period, in which case there is a remote possibility someone could come in front of us and full appeal, and we could have to stop construction while we figured out the appeal. In the 10 years that I've been on the board, that's never happened, but do realize there is a 21-day appeal period.
Well, Do you have the bulldozers on the site right now?
No.
Yeah, so it's hard to mobilize in 3 weeks, so. Plus, you've got to move somewhere, right?
I'm going to live with them.
Oh, okay.
In their condo.
What if that doesn't work out?
Come live with me.
You come back and appeal it. Wait a minute.
I got a
Anyway,
shed.
It is at your risk.
yeah.
It's not much of a risk, but it is at your risk.
Also, check to see if the fire department might like to do a training burn on that.
You know, I actually truly wanted, I offered the house as a thing, and the state gave a permit, the fire chief said okay, the building inspector said okay, and apparently a selectman said no. I was not there, I don't know who it was, I don't actually have any of it. I would love to do that. I'm a fire alarm operator.
Oh, that would be.
So I work for the town of Bedford, and that's
Yeah.
what I do, and I know how much these guys would love to use my house as an exercise.
Well,
And I would
yeah.
really like them to use it.
Up near me on April 2nd, they had a training burn.
Did they?
It was wonderful, yeah.
Really?
Yeah.
Can you put in a good word for me?
Sure.
I mean, I don't know who I have to go through to.
I would contact Keith Bergman, who's the town manager, who sort of, is the selectman's agent, and find out what the issue was. And explain your, it's not that you're doing this for prurient interest, you really have a.
It's a personal interest of mine.
Yeah.
Yeah, exactly. I think that's pretty compelling.
Without
to James.
amazing
Yeah.
training,
Yeah. Yeah.
Talk to Carr,
Yeah,
because,
Jim
Carr was
Carr.
right up the street from this one, and he knows all about that kind of thing now.
Yeah, 'cause I would love to have that happen.
Saves you a lot of deconstruction, too.
It probably would, yeah.
Yeah.
That would be great. Okay, so name one more time?
Keith Bergman,
Keith Bergman, okay.
who, he's not a selectman, but he communicates with all the selectmen.
Town manager.
And then there's.
Town administrator.
He's the town administrator.
Right.
Town administrator.
And,
Okay.
yeah.
'Cause I would
He
really.
he may know what the issue was, or.
Yeah, I would really like to see that happen.
Okay. Thank you.
Thank you.
Next
Hope we
up,
get him to Littleton fast.
Yes, me too.
it's 7:37. We have case number 885A. This is a request for a variance pursuant to section 17328, street frontage exception for reduced frontage lot at Lot 8 Boxborough Road. This apparently has quite a long history, has been before the board. I'm going to read I'm going to read several things. What the building commissioner has written, and then there was a Steve Ross Associates letter, but I think that's basically what Roland's written here. The applicant seeks relief from 17328. As described in a letter from David Ross Associates, the Board of Appeals previously granted said relief on July 10th, 1995. Was anyone on the board at that time? Cheryl, were you?
No.
I wasn't. Rod?
No.
No.
And the variance was properly recorded. Rights authorized by a variance must be exercised within 1 year of granting, or said variance shall lapse, which is what we're here for today. As such, I believe the variance expired before the lot was approved by the planning board as an A&R in September 1997. Chronology of events are as follows. May 1995, Planning Board recommends not approving the variance request before the Board of Appeals. April 1995, the applicant Ross Engineering petitioned the Littleton Board of Appeals for relief from 17328F. July 10th, 1995, Board of Appeals decision granted. July 17th, 1995, Board of Appeals decision recorded. September 1997, Planning Board approved A&R. October 1997, plan was recorded. No further comment. Do you have anything to
Do you
add?
have a town map to show us exactly where this is? Plot
The
plan.
only thing I have is a copy of the A&R that was endorsed by the board and recorded in 97. And on that, there's a locus map. It's basically a dead-end road that then ends up to
Here's
Route 2.
the whole parcel.
Correct. It's right across the street from a piece of property the town was thinking of purchasing.
Just to clarify, especially for the video, you are,
I'm Kevin from David Ross Associates, and I represent the Home Scout LLC. He's the applicant in this matter.
So
this
this is
is a-
Boxborough Road coming, oh, I see. So this is Boxborough Road, that's Coughlin Road, here's Crestview and there's Newtown. So this is off the back of Crestview.
Actually, it's off of Boxborough Road.
Oh, I see.
Right.
So it'll be
Across
a
the
road
street
that
from you,
runs
Joyce?
It's closer to Hoffman Road from me, but yes, it's on the other side of the street from me.
If you were to put yourself on this map, Joyce, where would you be, down here
Yeah, somewhere right there, yeah.
Can you mark it on here?
Can't see from this distance.
Oh, come on up, honey.
That was
Would you-
lot 8.
you
I
would
put
be
in
down
number
somewhere-
8.
Right,
May not
You'd be over
right
here
spot.
somewhere?
right, so this is
Yes.
Crestview here, and this is Boxborough Road, and comes to the dead end right there?
I guess.
Yeah. I gotta get oriented on that. I don't know if this is right. Because-
No, when I put in $8, but, you know,
Do you have
and
a
I'm
quorum
sure
without
that
me?
wasn't the house
No,
number.
you have to vote on this. We need 4.
All right, so I want to disclose something and give everyone a right to object to me. At some point in the past, I walked this land with somebody, I didn't have any gain any finances about it, but I walked the land with the person who owned it and was trying to develop it, and I suspect before 1995? Was that,
No.
It was probably
Anto Hartai.
yeah,
Right.
many
It
years.
was a while ago, 95.
I have a real estate business here in town,
Yeah.
but,
And that's who that plan was done for.
so I walked this at some point. I did not list it, I did not sell it, I did not make any financial gain off it, but people should have the right to object. And that would mean you would postpone for a month,
On what basis would there be an objection, though?
in that I looked at it with a business eye. I don't know. I feel like I should disclose it,
Okay,
though.
that's fine.
I don't know if anyone has the right to object, but, okay.
So, all the evidence indicates, the variance was granted, the variance was recorded a week later after the variance, that the plan was submitted and approved by the planning board with the notation of a reference to the zoning board of appeals decision. It's Roland's interpretation that since 2 years or more than a year has passed since the variance was approved and recorded, that the approval not required plan should not have been endorsed. That's his contention.
So how many feet of frontage, is it right to ask questions now?
Yes,
Ask as many
yes, go ahead.
questions as you want.
Yeah, Cheryl.
And it's been a long time. So how many feet of frontage do you have here?
Well, you have the plan in front of you. It says a total, I believe.
It's approximately 80 feet.
It's approximately 80 feet.
Don't you only have to have 35
Yes.
feet?
What the-
If you have 150 feet on the
On either side.
adjacent, yeah.
Correct.
So which is less than in this case.
Well, you have more than 80,000 square feet, so that's covered for
That's correct.
Yes.
pork chop.
So this isn't a density issue.
Right.
So how did this come about?
Well, like Jeffrey's saying, that the lot has got a reduced frontage lot, has to be separated by another full standard lot of containing 150 feet.
Oh, was this
So you-
originally supposed to be a road?
It was,
In which case you could have the reduced frontage on either
correct,
side?
exactly.
I see.
So that's the reason why the variance was submitted and granted, is because the lots on either side do not have 150 feet of frontage. So therefore, they classify it as reduced frontage lots.
Right, but we're not talking about those lots.
Now,
No,
are
that's,
these,
well, we are and we aren't. The reason if they have 150 feet of frontage, then we wouldn't be here.
so you wouldn't, so if,
I'm surprised
Is-
you should have to be here at all.
is the whole parcel, no, this is a serious, no, because if, he needs to be here because there are strict rules about frontage and lots, and they are taking what was left to be a road and turning it into a lot.
Well, let me ask you this, do you own this?
Yes, absolutely, yeah.
Okay, so it's 35 feet of frontage, over 2 acres, 150 foot square is shown in there. That meets the definition of a
But
limited
it was
frontage
broken,
lot.
it was broken off, not allowing 150
I-
feet on
I-
either
I
side.
think we need to decide whether we relitigate this issue or just affirm what the board did in 1995.
Well, that's gonna
when
be my
they
next
granted
question,
this variance.
I have a couple more things I want to understand.
course,
before I-
yeah.
Before I even decide whether I want to relitigate or just or just revisit that. I want to understand, is the whole parcel owned by the same person still?
That's correct.
It is owned by the
Correct.
same person. So you're seeking...
Well, no, let's, not back in, it's a different owner than that was approved on, that owned it at the time that approval not required plan was done.
So is this piece of land here that Lot 8 is part of
Yes.
still owned by the same person?
It's owned by one person, but not the person who owned it in 1997.
I see.
But that plan, like I said, was endorsed by the board and recorded at the Registry of Deeds. So it was submitted to Roland for a building permit for it because it has an approved septic system. It had an approved septic system back in the day, back in '97, but the regulations have changed now, so the density of the septic system can be reduced. So there's a new septic system designed and approved on that lot.
Is it your understanding that you will then have to go to the planning board?
It has been suggested by Roland that once the variance is granted, then we have to go back to the planning board, more importantly, to get clarification and more specifics on that note that's highlighted on that approval not required, because that references the variance in 97.
Which has expired.
Correct. So if the variance is granted this evening, then we'll have to go back to the planning board with basically the same exact plan with a different date on the variance.
A
Now-
different owner.
Different owner,
Now,
correct.
do you-
Yeah, because it may not be transferable.
Do you, Roland is our zoning officer.
Mm-hmm.
Do you dispute his interpretation of this?
I'm not an attorney. I have my opinions, but in terms of what Roland, he is the zoning enforcement official, and if he feels that it requires a new variance, then that's what we're gonna do.
Okay.
And if he also requires that we go in with a new approval not required plan, that's what we're gonna do.
Do we have the original
Can we have
variance?
some discussion without closing the hearing? Because I'd like to keep him up here to ask questions, but I'd like to talk to you guys too. Is that possible?
Yes, but I'd also like to hear from anyone in the audience who has comments on this.
Can you help clarify what the frontage variance is exactly?
When this
So
lot...
I understood it
We
was, I
had
thought
the-
it was 150 feet of frontage you're required to have.
No. If you have an adjacent, if you're subdividing a property, you can subdivide it in such a way that it has, that one lot, two lots confront, one lot has 150 feet minimum, and the other lot can be 35 feet. So but you can't do that indefinitely. You have to have, the 35 feet has to be, have 150 feet on each side.
So you can do 150, 35, 150, 35, as long as the one that has 35 feet has a minimum of 2 acres. It's called a pork chop lot. So it has a reduced frontage, but it's required to have 2 acres instead of 1. So you can have one lot that's 150 feet and an acre, then a lot that has 2 acres, but only 35 feet of frontage. Then you must have another lot that has at least 150 feet of frontage and at least 1 acre.
That
When
applies
this
if
land
you're
was-
subdividing the land, not if you're just making use of land.
No,
that's here.
This is-
when this land was subdivided, it was subdivided with this as a road. These were subdivided as lots that didn't have 150 feet of frontage, such that they would not allow a pork chop lot here. This was subdivided this way, with this only leaving enough frontage
Well,
for a road.
do we know that?
Yes, we
Well,
do know that.
Those lots were created in 1956.
Okay.
So that bylaw wasn't in effect at that time. You didn't need 150 feet of
These
frontage.
houses aren't that old.
The plan that created those lots was done in 1956.
Plans aren't valid that long, and I mean, we just saw that with Durkee Farm, where they had laid out a whole mess of lots and acres, and it wasn't valid still.
Well,
So-
I respectfully disagree, because Long Lake is done on a plan that was done in 1926, and those lots have been conveyed.
They're all grandfathered now. I'm
Okay.
saying these houses weren't that old, and I'm saying if this was subdivided, I mean, I'm not saying that you can't do this. I'm just saying I have real heartburn over this, because it was designed to be a road, and we're making it into so it was left with reduced frontage, and we're making it into a lot. And
We are not making, this lot was made in the past.
no, because it's still the same owner.
What does that have to do with it?
It's still the same owner as the whole piece. this whole piece, this whole
This
whole
lot
piece.
was created in 1995.
But this whole piece is still one owner. Legally, it's still
It
one lot.
was, it is not legally one lot. It was created into two lots in 1995.
And it expired then. and
That's
it's-
right.
And it's back
Only
to
the
being one lot.
variance
If you
expired.
buy
I don't know
a
if
piece
the
of
A&R
land next
expired,
door to
yes.
you, and it becomes the same piece of land again.
Okay, so you want, we'll have a discussion among ourselves more, but can I have some comments from any neighbors, abutters, any interested people?
I guess the question, what's the desired plan for what's gonna go in there?
Single-family residence,
Just one?
just one.
That's all you could put there.
That's true, but it, like you said, it was created in '56 with an access strip that could provide access for a road. They're choosing not to do that, and they're choosing to put in one single-family house with a one single driveway.
Yeah, this land is very wet back here.
It is.
They can't really develop it as development, is my understanding. I could be wrong.
Well, there's some
Could have
wetlands
changed.
coming in.
When I walked it 15, 20 years ago, it was very, very wet.
Well, that's their issue with the Board of Health and Conservation Commission.
Absolutely,
not this
yeah.
board.
We're just there to get a variance for the frontage. We're just getting here because the variance expired, is really what we're here for.
Yeah, and it's not appropriate to say they can't do that, because then you're landlocking that lot, and that's not fair to the owner.
No, because right at the moment, it is part of the whole thing.
No, this lot right here, its
It's
access is
part
here.
of this whole thing.
Yeah.
And it has access on Crestview. And it still has road access here, but it does not have a lot frontage there.
All this land, but he wants to break this piece out.
Yeah.
So,
All of-
okay,
that's
hold
fine.
on. Any other comments from the? No, okay, Cheryl, go ahead. Oh.
Is there another way to access this lot besides this?
Yes.
Crestview.
Oh, no, which lot?
Lot 8,
Well, no,
besides Foxborough?
No.
On the other side?
no.
It goes to Crestview, but you can't go up.
But
there.
we're dealing with a lot that was created in 1995 that's delineated on this plan that shows a access from Boxborough Road, though it is contiguous with the parcel that has access on Crestview. Though this particular lot is just coming from Boxborough Road. If you want to come up and take a look at it.
And it would mean a much larger access drive to get to it.
I was gonna buy this land, but.
Okay.
This way.
Okay.
Do we have the original
Oh,
variance?
we
here?
should get anyone who's
I do.
talking to say who they are. Aren't we supposed to?
Yes, or they can, we don't have a signage.
This is the recorded variance that was done. And actually Sherry Gould was an alternate member on that. Her name is mentioned as an alternate.
Really, I thought she was a regular member since dirt. She's been on so long.
It's been a long time. That's 22 years ago.
Yeah.
Can we get everyone who's spoken here tonight to state their name for us? Because we're supposed to.
Yeah, Wayne Bolivar, I'm on 40 Boxborough Road.
Paul McGregor, 36 Boxborough Road.
Joyce?
George Williams, 31 Boxborough Road.
Scott Santos, 16 Foxborough.
Would you state your name for us?
Kevin Conover from Ross Associates.
Thank you.
No.
All.
This doesn't spell out what the variance is, it's just spelling out, it looks like, recording it.
I think at the end, the next page is the findings.
This looks,
Excuse me, Lisa Flanagan, 5
Okay.
Pine Road.
Mhm.
A bunch of us were downstairs in room 103, the Oak,
Yeah.
all road.
All of
issue.
us, we've received these and it said that we should come to.
Oh,
room
this
103.
was for the first hearing?
It was for the 725.
Oh, I'm
Case
sorry.
Is it over?
885 for us, and then there was a couple of others.
It is over. We're in the middle of another case. If you want to, this probably isn't going to take that much longer. If you want to wait a minute, we'll review what we did with it. So if you, I'm sorry that for the confusion. They moved us up here. Usually that is our room. They don't,
They didn't even have a sign.
I'm
We just
sorry.
sat for 25 minutes or something.
We're really, yeah, our secretary is out, our chairman is out, we're,
I
I'm just curious, I don't want to, I know you're, but I'm just curious, because we people who live on Boxborough Road were not present during.
Boxborough Road?
Yeah.
Oh, no, we're on
That's
Boxborough
what we're
Road.
talking about
Oh,
now.
We're in the middle of Boxborough Road.
Other people,
Okay.
okay. All right.
We're in the middle of that, so to catch you up, we're discussing, he's just presented this, and we're discussing it.
Oh.
And you're not too late to have your say.
And we were just inviting anyone in, who's here to to share their comments or concerns.
But please state your name and your address when you do so.
Well, I'm Sue Prieto, my husband's Artie Camacho, who wasn't able to make it tonight. We live at 22 Boxborough Road.
Do you have any comments?
Yeah, we'd like to protest the variance.
Where do you live on this plan?
May I approach? I can't
Please,
see
come on.
it.
Is that all right? Can you take that? Okay. I say that when Sherry's sitting there, so I don't keep it. So where are you on
We're
this
22
plan?
Foxborough, so this is Foxborough.
Do you abut
This
this?
is what, this must be us, we're 22.
Correct. Is that you?
No.
No, then we would ask the previous owner.
Oh, the previous owners weren't that either. We bought this in May of 20, we've been there for a little over a year.
How old is your house?
So, I mean, it's, it's a ranch. I don't know how old it is. We bought it in May of I want to say 2015. Foxborough Road.
Yeah.
This is the,
Is it 1950s
this is the
house?
supposed easement to get into this pork chop lot. Is that what we're talking
It's
about?
not an easement, it's actually part of the law.
Okay, right. So we live right here, but that's not us.
So what was your understanding when you bought your house?
That we were under the impression that there was a potential for a buildable lot, although it was, when it was advertised, they said it was conservation land. So we were a little bit up in the air. And
Who said it was conservation?
I think the Realtor, quite frankly, when we were interested in that purchase, it was listed as abutting conservation land, and so people got it before we did, and the people actually backed out of it because it was buildable, and they didn't want to go through that. So just so you know.
We're Diane Bernier, Josh Bernier. We're 26 Boxborough Road.
Which is where?
So
the other
we're
side.
on the other side of her.
Oh, you're on the
Okay.
other side of the little.
No, we're
You're
over
Over
here.
here, okay.
So we're here to support her.
And how big is your lot?
And also the lot that is being built on, it does come, so.
Yeah, it abuts your
Yeah, it abuts us,
Yeah.
so.
So how big is your lot? How much land do you
An
have?
acre.
An acre?
Yeah.
We're about an acre or two.
And the reason for the objection?
What's that?
What's the reason you're objecting to this?
We think that's going to impinge upon our freedom for peace and quiet. And also, we're worried about the destruction of beautiful woodlands behind the homes.
And about how it would affect, there's like traffic, because as of right now, I'm not sure whether it's gonna go further back, whether they're planning a whole.
It's
this-
one house.
This is one house, correct, but
And
we
it will
have heard.
preclude any other access from Boxborough Road for any of the land behind
We can say that.
it. No.
Right
You
now,
won't have a pass-through from that
No.
driveway down to Crestview, for instance?
we can say that. We can make it conditional upon it.
Well, it's the way the land is subdivided.
No,
There's-
because they could still.
Our understanding
they could
is that
still
the
come-
person
they
who
could still
owns
put a
that
road in front of
lot
it.
also owns a property
Yes.
down by Crestview, so maybe in some future moment, there might be actual cut through.
Well, why don't you
Which
come-
would really,
Why don't you, there's an overall plan here if you want to.
I can explain this to you. The reason we're here is because there was a variance granted by the Board of Appeals back in 1995. That variance was recorded at the Registry of Deeds. 2 years later, this plan was presented to the Planning Board, and it was signed by the Planning Board in 1997 with a notation on the plan saying that this division is pursuant to a Board of Appeals decision, approved and recorded. So this plan is already recorded at the Registry of Deeds, already approved by the Planning Board. So
But the variance expired?
that's correct. So the reason we're here is because Roland, the building inspector in town, it's his opinion that the Board of Appeals decision has elapsed because you had to take action on it within a year.
That's our understanding,
So-
too.
Well, that's his understanding, and.
Well, you may or may not know, my husband and I were considering purchasing the
understand that.
property.
I know
So
that.
we did a lot. We had a realtor, a land person look into all of the coming and going of possibly what this land could be worth to us in some future date. And we understood that there was a question on whether if we purchase this now for our own personal enjoyment and peace and quiet, that if for any reason in the future we needed to sell it, that it wouldn't be sellable and or buildable at some future date because of this problem
Right.
with the variance.
And that's why we're here. We're trying to reinstate the variance that was issued back in 1995. The zoning regulations haven't changed since that date and for this particular division, so everything is consistent with the decision as was submitted and approved by the Board of Appeals in 1995.
But to your question, it does not allow for access to the other land that is.
Correct.
That's wrong.
No, he's
How is it wrong?
He's
Because
actually
this is
correct.
one piece of land, and
It
right now
has
it
been
allows
some-
access.
It's
It's
Cheryl,
back to one piece of
Cheryl,
land legally.
It's not.
Legally,
well,
it's one piece of
legally-
land.
There may be a legal issue that we haven't, you
Right.
know.
No, legally, because it's all owned by the same owner.
If
So legally, this is all one piece of land.
If this is, if this lot, which is a lot, if this is here, there's no access you can go through to
And
that.
can I just interrupt for
No. There is no reason, this is wide enough for a road. There is no reason at some future date that they couldn't come before the planning board and say, this is wide enough for a road. We're doing a land swap with this. This is magically all dried up. We're going to build houses back here. There's absolutely no reason
The
they couldn't do
reason
that.
is that is completely unlikely.
Well,
And
I agree.
completely
It's-
unlikely
Wants to
to
live
be-
on that,
But it is
completely
complete-
unlikely.
I mean,
That's not definition, that's not definite.
You have no,
Basis.
you have no, this is someone else's property.
I understand.
And, well, whatever.
Well, and.
Well, I will tell you that.
I'm
it's a concern.
reacting more or less to
All right, well,
Cheryl's
it's a
comment.
concern.
I would entertain this if we can put a deed restriction on it. And I don't know if we can. If we can put a deed restriction on it such that the driveway can never become a road to other lots. People have a right to use their land as they want. And you don't have a right to say someone can't build a house on land that's not yours. And that, that you just, it's their land.
I'm worried about cross-traffic. Like, we have Coughlin, and it's kind of a blind road, and you're kind of going downhill. So another road where people are cutting
Yeah,
through.
I understand your concern
We're
about
not,
a road.
we're not talking about a road, we're talking
So-
about a driveway to a single home.
But it legally, and it is potentially possible, and we've certainly seen land swaps before, that they could add land to the back of this, and this could become a road. So I would entertain this if we can put a deed restriction on this piece of land, that can never become a road.
If something like
I would
what you're,
appreciate, we would
Yeah,
appreciate
that's
that.
if
super
something what
important
you're
to us.
proposing would come about, they'd have to come back maybe to here.
No, they would
definitely have
not.
to- They definitely
If you go
have
to
to
the
go
planning
back
board.
to the planning board to get an A&R
No,
to further subdivide
they
that
would.
land.
They would get
Yes.
it A&R, which is approval not required.
Yeah.
And
For a
That's still a
road,
decision by the planning
you
board.
can't
It
go
is-
and build a road without a planning board approval.
approval not required. It's wide enough to have a legal road. So, yeah, you have to get the firemen and everyone,
Through-
but they can't
through an
stop
eas-
them. They
Whatever,
cannot-
fine. I don't think,
It's
well,
not-
we can do this in deliberations, but are there any other comments from, yes?
Joyce Williams, 31 Buckspur Road. I don't know whether you realize from looking at the maps how steep that road would be, the driveway, and what the drainage problems would be, and how that would affect the abutters, the immediate abutters.
How would it
addressed in the original-
affect the immediate abutters?
They'd have to put a lot of fill in there.
That was,
I think.
that's
Or
addressed
put a
in the
bridge.
original decision here.
Yeah.
So if we were to reaffirm this decision, I think that stuff's covered.
I gotta tell you, if I was back on the board back then, I wouldn't have voted for this. I wouldn't have. I would have not voted for it. I would not have, because this is taking what was divided off to be wide enough as a roadway and turning it into a lot, and it still leaves open the potential for it to become a roadway through. I walked it with the idea that it was going to become a roadway and that there was other high land back here, that could be developed.
If we denied them and they sued us, they'd win.
No, I don't think
That's
they
not
would.
just, that's not a valid reason to deny it.
I will tell you that that's the only reason my husband and I even entertained the idea of purchasing it, because we heard that they were gonna make that driveway access down to Crestview at some future date. Whether that's true or not, or buildable or not, it's a real concern for those of us that abut this land.
Okay, can I just
That's an
clarify?
appropriate concern, but
It's
that's
very
not,
appropriate.
but they're not proposing a driveway, I mean, a road, they're proposing a driveway to a single-family home.
So in the future, if they want to connect.
Which the
them,
home would have to be built where this road would have to be.
Can I just clarify a couple of things?
Yes.
First of all, the variance as submitted is not for a road. It's just to make this a reduced frontage lot. So we're not proposing a road. If we wanted to propose a road, we'd have to come back, like Jeff said, to the planning board through the definitive subdivision control process, not through the A&R. Because anytime you create road frontage, you have to go through the definitive subdivision. So that is a public hearing, that is design, that is a lot of work.
Let me
So-
But it's a lot of work, but they couldn't stop you.
But this variance is not for a road.
I understand
The
that.
submission is not, the request is not for a road. It is for just a lot, one single lot.
I can bring myself to approve this and accept it if it gets a deed restriction that it can never be a road.
For that,
It can only be
Okay.
access for a single lot.
okay, you have to be careful with that statement, because my client's not here right now, but that is for that one lot. You understand that? Not the whole property, just that one lot.
It is that this lot.
That lot.
This lot, that this access can only access this lot,
That one lot.
that one lot.
Okay, because you're wording it a little different, and I don't want to put some undue restrictions on the rest of the property by saying that you can't put a road through, you can't put a road in.
Oh, absolutely. I want to say, you cannot put a road through here.
Well,
Can I make a suggestion?
Sure.
We continue the hearing till next week, till we get a five-member
Next
board.
meeting.
Next month.
Next meeting, because we're running into a problem here. And secondly, you have a standing A&R. Check with the planning board to see if that's still a valid A&R and it did not expire. If it is, and yeah, then ask them if they still need to refresh this variance. I think you have a valid A&R. I don't really think there's a need for you to get a variance from us, but that's my opinion.
Well, we are here to
Roll.
uphold the building inspector's decision in this matter. But I would bring an attorney to, we don't, our chairman who's in here is a real estate attorney who may have some insight into this. But I guess, I don't know why I'm telling you to bring an attorney, but this is a complicated matter. And I would
You
say,
can get your approval today, but you're going to need to put a deed restriction on the property that it will, that this access will never be a road and will only access this lot.
And I think that's inappropriate, so I'm not sure I would favor.
and
the
I kind of agree with him. The variance as, no, we're having a discussion here. The variance as submitted is for one hammerhead lot.
Yeah.
And that's all we're asking for. We're not asking for a subdivision road.
You are
To be honest with
leaving
you,
yourself open to put in a subdivision road there.
That's down the road, they have to go back to
They
the planning
can't put
board.
a subdivision
There's
road.
protections.
If you want to be perfectly honest, they can't put a subdivision road down there without a waiver, because that access strip is only 40 feet wide.
I thought you told me it was,
The
Well,
access,
75 for
frontage,
right,
but
but the
frontage
access
is
strip
both
is,
south,
is
north, south.
40 feet
could
wide.
you even meet the grades required?
Well,
I
you know, we'd have to look into that, obviously, but grades are an issue. So for us to put a road down, for my client to put a road down there, there'd have to be serious designs, because you have to have, I think it's 42 feet of an access strip for a subdivision road.
okay,
And
we've
Chair-
opened the hearing. We're going to have to close the hearing.
No,
And I-
continue the hearing. Okay.
Well,
I don't think we can continue the hearing unless he requests it and we vote on it.
Yeah, but, one of the things you're missing is he owns the rest of that land. He has the right to come back with a plan to put more houses on there if they want. It's not our purview to say they cannot do that. He has the right to develop that land. if
It
he
is
can
our
bring the road.
purview to say that he does not have the right to put this to build this lot with less than 150 feet of frontage. He has 73 feet of frontage. He needs to have 150 feet of frontage.
He has a legal limited
The
frontage
planning board,
lot.
when this was approved, the planning board turned him down and recommended against it. They came to the
Yeah.
Board of Appeals, and for some reason, the Board of Appeals at that time decided to approve it. At that point, the planning board had no choice but to then approve it, because we had already approved a reduced frontage lot. I have a problem with this. I don't think that we should have approved it back then. It's expired, and now we are approving it now. And you're leaving it, not only that, you're leaving it open to further down the road to becoming a road into what I admit right now is land that's probably too wet to build on, but you're still leaving it open.
He
And
has
you're
the right to do that if that's the case down the road.
If he wants a bill, and we have the right to say that he can't have a reduced frontage lot.
I don't think so when when this
We-
lot itself meets the bylaws.
It doesn't.
It does.
It doesn't. It doesn't have 150 feet frontage, and the lots on either side of it don't have 150 feet
He
frontage.
is talking about this particular lot, not the two adjacent to it. The two adjacent to it were done back in, what, the 50s or something?
Okay, so
That's
this lot-
past tense. They're grandfathered then. We're talking about a pork chop lot that meets the zoning requirements.
It cannot be a pork chop lot because the lots on either side of it don't have 150 feet.
This is not related to the lots on either side because he does not own that property. He's not subdividing it with that ownership of that lot.
But if I wanted to
no.
if I wanted to pull a lot off my property, create a lot off my property, I have more than enough frontage to do so. If I wanted to pull a lot and make a lot on my property, just because I first divide it here and say that, oh, I'm only going to put 120 feet here, and by the way, my neighbor over here only has 120 feet, but I already divided these off. Now, I left enough room for a road, but I'm not going to put a road there, so now I want a reduced frontage lot. It doesn't, he has no right.
Please.
Can
I think he
ask a
does.
Quick question. The variance is for a reduced frontage lot. Why was the rule put in the first place you have to have a certain amount of frontage on a lot?
Wait, this was planning that was established in the 1950s. And there are many, many neighborhoods in this town which have pork chop what they call pork chop lots. When you see a driveway just disappearing and the houses behind houses, I live in a street like that. And what the trade-off was is that if you do establish a pork chop lot, you have to have a bigger lot. So these lots are 2 acres instead of 1 acre, or 80,000 square feet instead of, and so that was the trade-off. Now, you have a situation here where we have 4 people, we have to have a unanimous decision. So if we go to a vote today, you may not have one of the votes you need. And I think that the deed restriction is superfluous. I think that if this is established, there's no way that there's going to be a road going through. But whatever, if that's what is required for Cheryl's support, you may wish to consider it. Otherwise, you may wish to continue it.
Well, I guess that's going to be my question. If I agree to the deed restriction on that a subdivision road will not be proposed through that access strip, will I get the variance?
That's what Cheryl's concern is.
I've said, yes, I can bring myself to vote for this if we can put a deed restriction on this piece of property that it will never be an access road.
On that lot?
On this lot.
Correct.
That this piece of property right here, this one, will never be used as an access road.
That's part of this lot.
If
Right.
you're specific about that one lot,
Yeah, I don't,
Then-
you know what?
then I'll
He has a
agree to
right
that.
to do anything he
Then I'll
wants.
agree
He's
to
got
that.
plenty of
You're
frontage
just
down
telling me he
here.
doesn't have the right.
On the other land. On this land down here, he has a right to do whatever he wants. He's
That's
got
right.
plenty of frontage.
That's
This, he doesn't up here.
okay, I'll agree to that. If she wants to put a deed restriction on that will not be a subdivision road in the future, and we get the variance, then I'm pretty sure my client will agree to that.
Okay. And that, I think, satisfies
Do
and
you
is
have
the
any
best
other comments?
protection I can give
No,
you
but I'll
for
make a
anything.
statement for the record that
So
I don't
to
think a
clarify,
deed
this
restriction
means
is
that
appropriate.
if you grant him the variance and he builds a house on it, that at no point will they ever be allowed to connect Boxville Road to Crestwood Road.
Right, or not through there.
Not for them, right?
Not there. There's nothing to stop them from buying one of your neighbor's pieces of property, tearing down a house and putting a road there. You know, what we're saying is,
The deed
this
restriction.
piece of property itself won't become an access road for the rest.
It's just in and out to that one driveway.
That driveway,
We
yeah.
never cut.
And it's just a single driveway.
That's the best protection we can give you.
Mark,
Thank you.
any comments?
I think it's more technicality than anything, the whole regulation about having 150 feet on each side. The only reason it doesn't is because when they drew up the map, they put a radius at the end of the road. If that 40-foot road was 40 feet right to the, to Boxborough Road, then there would be 150 feet on each side. So the intent of the regulation was to prevent, not necessarily congestion, but having a lot of houses close together. This is technically in violation of that. And so, I don't have a problem with granting the variance,
Which has previously been granted.
which is previously
My
granted.
concern is this variance, this is I think it's a technicality that the variance expired. And it had been approved by both this board at the previous date and the planning board. Spatially, this is a large lot. It has there's the land, the land exists already that's not your land. And so I don't have a problem with this. And though I don't feel that someone could achieve a road through this lot, Cheryl does. And so
We've seen all kinds of things
I-
happening here, Jeff.
I
And he
can't-
does, and they
We've
put 2 or
seen
3
two
houses
on a
down there.
piece
What's
of
the big
property
deal?
Get moved and said they're gonna be one piece of property in condos, and then suddenly we're subdividing them again. We've seen all kinds of things happening here, and I have heartburn over this. I would not have granted this back in 1995, or certainly wouldn't have voted for it in 1995. It's expired, it's here in front of us before. I understand what they want to do, and actually think it's in the neighbor's best interest if we give him what he wants, as long as we assure ourselves this can't become a grandfathered road in the future.
Okay,
Well,
are there
it
any?
won't be grandfathered because it's not a road now.
They make cart paths into roads. They call
But
those
they aren't
cart paths,
grandfathered.
they are grandfathered, across
Do
wetlands and all kinds of things.
I have a motion to close? Is there any other comments?
Yeah.
Before we close?
I just have another comment, that if you were to go to the planning board and they felt that the variance or the A&R is still in effect and they don't want it, they don't feel variance is needed, you could probably go to the building inspector and get his okay and then not even need this.
Well, I would tend to agree with that, similar to if the lot was not a hammerhead lot and it didn't have a variance. If there was a plan that created a lot 40 years ago
Yeah.
that still conforms to today's standards, you can walk in there. An A&R doesn't expire.
Yeah.
Once it's been approved by the planning board, and if it today conformed, if it conformed at the time and it still conforms today, then you can
Yeah,
use that A&R.
and I think you could still use that argument with the building inspector. The A&R was granted based on this this variance.
Correct.
The A&R is still in effect, and you should be good to go without having to be back here.
I
That's
think
my opinion.
Roland's correct that it is not.
Well, our argument
I
was that,
disagree with that.
Roland's opinion was that action wasn't taken on the variance. Well, we made the argument to Roland that, the variance was recorded at the Registry of Deeds, that signifies to us an action. But he
Would he have
doesn't.
considered the A&R within the year an
If-
action?
Exactly.
and
If-
that's the other
that
part.
was the
That was the other
technicality.
thing, right.
Yeah.
If the A&R was approved within the year of the variance, then the variance runs with the land.
Okay.
Because the action was taken. Now, Roland has his opinion, we get along great with Roland, we think
Yes.
he's
We do
he's
too.
outstanding.
Yeah.
So we're gonna do whatever he wants.
Okay.
So we agreed to disagree, is basically what it
Okay.
is, and that's why we're here.
Okay. Do I have a motion to close?
Actually, can I just
Oh, sure.
make one
Yeah, yeah,
comment
yeah.
or something like that? Just, it seems like the biggest sticking point here is that the current plan is for one house.
Yes.
There's a concern that I think the abutters and people living on the road have that it could lead to more. Kevin, is there anything that you guys can do to
We're
ensure?
Cheryl is
Well,
proposing
no,
the
right,
deed
no, I
restriction.
understand.
Yeah.
It just sounds
No.
like there's a little bit of.
There is nothing we can do to keep them from putting an access off Crestview and developing all the rest of it if it magically dried up.
No, I'm asking Kevin if there's anything that his, or the building plan can do to help for, I know that
Well, once.
You know, you get a foot in the door and you can, you know, things can happen later on. I'm saying, is there anything that your company could do, or that you could do to lessen the likelihood of
Well,
that
can I answer
happening
that?
in the future?
Yes.
Once the plan is approved by the planning board, it'll be self-contained to that area of Boxborough Road. The access strip coming in off of Boxborough Road, going through those two houses to one buildable lot, one building lot. Now, once that lot is built on and conveyed, it's in its own entity. There's really nothing you can do unless you, down the road, purchase parcels from other abutters like they've indicated.
Yeah.
But once the plan is approved by the planning board and sold to another entity, it's just a lot.
But you could never take that driveway and continue on and expand it.
Well, that's
more
what this,
houses
yeah,
down.
that's what the
That's
whole,
why
the
I'm
thing about the
insisting on a
deed
deed
Yeah, no,
restriction.
yeah.
So
Right, right.
if we ever propose that variance, similar to this variance as is recorded with the deeds, runs with the land. So if we ever tried to propose a subdivision road through there, that would be brought up at any of the approvals. And that would probably squash anything saying, well, you can't do this because there's a deed restriction on it saying you can't.
Until you come back to this board and ask for it to be
Yes,
rescinded.
you know, there's other mechanisms, but for this particular submission, this is just for one hammerhead lot, or pork chop lot. And it's my client's intention to sell that. So he's not, you know, hopefully within 6 months, it'll be out of his control.
I would say that I think
that answer your question?
you are
Yeah.
correct, is that we don't usually, well, anyway, I don't want to muddy the waters. I think today we would not have given this
Granted this.
variance. It would have
No.
to have been a planning board thing or whatever.
The planning board refused it. They came
Yeah.
to us.
Yeah.
We said yes, so then the planning board had no choice but to grant it because we had already said yes. If I'd been on the Board of Appeals back then, I would have said no. But I wasn't, but it's expired. It has to be renewed. We're here. I'm willing to do it as long as the motion includes wording to put a deed restriction on the access to Boxborough Road such that this particular piece of land can never become an access road to any other lots.
Can we just be a little bit more specific? And I'll agree with you, whatever you guys want to do.
Would you like to write down what you'd like it to say?
No,
As
because
long
you
as-
guys are
as
so
long as
good.
I'm happy.
That
wanna
makes
make
sense.
sure it's
I want to
just-
know why
yeah.
you're sort of, to part of my.
He wants to
why
make
is-
sure that I'm not restricting the land
The land, that's
elsewhere.
exactly.
The other
that's
land,
exactly.
yeah.
So if we can just be specific about the access strip as indicated on the plan approved by the planning board in 1997, will not be used in the future for a subdivision road, something
Well,
similar
we'll
to
call it
that.
Lot B, because this is part of Lot B. And we'll say that no time can,
Lot 8.
Lot,
Eight.
Lot 8, as shown on this particular plan, the access to Foxborough Road can at no time be used
Right.
as access for any other dwellings.
Well, can we just say not as a subdivision road? Can we use that, be specific as that?
I think it says the same thing, but
No, because then it could be a shared driveway, is what, I'm saying it can't even be a shared driveway. He's trying to make it so that it can still be a shared driveway.
I'm not saying that at all. I'm saying that it's not going to be a subdivision road. And I
I'd
think
like to know that if that pork chop lot and that driveway that will access this potential building in the back, if that driveway can only go to that lot and can never be an easement for another house behind it. Is that you're
That's what
arguing?
I'm talking about.
There's a
He's trying to leave the door open for shared driveway.
Yeah,
No,
that's shared
I'm not
driveway.
trying to do that. I'm trying to do what you said, that you didn't want it to be a through road to another road.
I want it to be for this
Well,
lot
that's-
only.
That's a different story than what you were talking about before. Before you were saying that you didn't want it to be a subdivision road.
I don't want it to be a subdivision
Okay,
road, but I
that's
also
fine.
want it to be for this lot only.
One lot, one driveway, that's.
I mean, there's no reason why in the future you couldn't come back to us and say, okay, we're gonna make our 2 acres here, or actually, go to the planning board, we're gonna make our 2 acres here, and this now is going to be the road off into a subdivision.
Which needs planning board approval.
That's right, but I'm saying if you want this to be a building lot now, you're going to have to allow this to be defined as a building lot and not a potential shared driveway or anything else. Are you okay with that?
No, I'm not. I'm okay with the subdivision road, but the shared driveway, I'm not. Because I believe that severely restricts any adjacent property to that lot. we could technically do a shared driveway on that. Where are we going to? No, that's not the intent. But like you said, everything is wetlands back there, the soil conditions aren't the greatest, the topography isn't the greatest. So if we need that in the future to get a shared driveway off of it, like it's gotta go to the planning board. I don't have any problem saying it's gonna be a subdivision road because there's 1,000 different reasons why it's not.
If we grant it as a driveway, then the planning board will be forced by our zoning bylaws to allow it to be a shared driveway for up to 3 dwellings, is it 3? Up to 3 dwellings. So if we grant this, as he is suggesting, there could be 2 more houses back there, which maybe they're right to have 2 more houses back there, but we are saying that we are giving a reduced frontage lot that then has a shared driveway of 3 properties. And that gives me heartburn, gentlemen.
But
I-
two
I-
houses
I-
on a 10,000 square foot lot did not.
Oh, it did. But I didn't know
You
how,
voted
but
for
then
it.
legally, I didn't know how to get around it.
Hey, this is not the time for that. So, what do you want to do tonight?
If you'll have the word subdivision road in the decision that it won't be not a subdivision road, that's fine. The shared driveway is a different wrinkle, and I can't predict what's gonna happen down the future. You know and I know that regulations could change to make that a shared driveway easier, harder. Same with subdivision roads. But I know for a fact that a subdivision road is not gonna be proposed for that access strip. But I don't know for a fact, and I don't mean to show conjecture here, that a shared driveway might not be put down there, because at this point, I really don't know.
I'm just as concerned about a shared driveway, just so I can voice my opinion about it. I mean, I know that people have legal rights to build places and they own property. I get it all. I believe my neighbors would concur that one driveway, one house, we can live with that. One driveway that eventually becomes a shared driveway because now there's going to be 3 houses, it's practically like having a road. It's like having a subdivision, except they're all going to funnel into the side of our properties, and we're going to have, Grand Central Station coming in out of there eventually, and I would like you to prevent that from happening. That's all I'm asking.
Okay, so we can turn this down and say no, in which case they can, eventually something's going to happen to this land. The gentleman who bought this land bought it as an investment or owns it as an investment and would like to develop it, and eventually he's going to succeed in some form or another. Breaking off this lot is the easiest way for him to sell a lot and go on with it. I understand your concern. I believe if he could get the road through, and if we make the land valueless, then there's a lot of value in managing to get a road through, because there's nothing to lose. You could end up with a subdivision road there.
So
And they've turned they have
grandfather.
grandfathered cart paths going over wetlands as roads. So
We have to protect our
I'm-
right to peace and quiet, and I understand
I'm
completely
trying to.
legally. I appreciate that so much. I think all of us do. It's just that if you can't make any kind of provision, one thing is like, of course, we prefer not to have a house behind us. The man has a right to build a house behind us, and he has a pork chop lot, and you need a variance to get the crew in there to build that house, and then the people who buy it have a right to come in and out of Foxborough Road so they can go about their business. If you allow tonight for that man to get a variance, and there's no provision that that one driveway belongs to that one house, I protest very vehemently about that, because if there's nothing you can do tonight to prevent a potential builder to go, okay, I got this house up, and then 5 years later, I'm gonna put a house right next to it, and then we're gonna go deep into back all the way down to Crestview, and next thing you know, that's a shared driveway for 3 units, you're ruining our own well-being, our own value of our property, and I really think it's an injustice. I really do. I mean, I'm ignorant about land. We hired a lawyer to look into it ourselves. Our lawyer even said it was problematic. We wanted to buy the property because we wanted to protect ourselves from...
And have a potential investment in the future.
Right.
And your lawyer said it was a problem with being investment. I understand. But you do realize that if we make this land valueless, then it becomes, then all of a sudden, the fact that he has to spend $100,000 or $500,000 to put a road in gives it value that it wouldn't have otherwise. There's got to be a balance. You can't.
Well, I hope I'm dead before that happens, because if you put a road in between
We're-
Boxborough and Crestview.
The matter before us is affirming a single unit pork chop lot. Now, we have a disagreement, you do not have Cheryl's support unless you basically make this access to basically a single lot with no future access to anything else. And so that is the situation we're in right now. So you either accept that and we have this the previous variance affirmed with the further deed restriction of one driveway, one house, or we continue it. Or it goes down, in which case you
Right.
have some years to go
Yeah,
before you can come back
then we'll
before the
continue
board.
it if that's gonna be the restriction. Like I said, I don't have a problem with the subdivision road, the definitive subdivision road, cul-de-sac, through road, anything like that. I don't have any problem with the restriction on that. And like I said, my client's not here, so I can't speak for him in terms of the shared driveway. I doubt that that's what they're gonna do, and like you know, if they did that.
How many acres is this lot, the whole thing?
The whole thing, I think there's a remaining land note on that.
11.
And if you're able to come back,
So-
I would suggest talking to your lawyers, because I don't think it's appropriate, and I don't think we can prevent you from developing the rest of the land with a deed restriction or something. I
This
think you
does
would get
not,
that turned
this does
over.
not
So I think you need to
restrict
talk
the
maybe-
development of the land, because there is other access to the land.
Maybe.
There is.
If it turns out that this is the only feasible one. But my point is, we're trying to restrict development. With this kind of comment, we're trying to restrict development. I don't think that's in our right to do. You may want to check with your lawyers and
It's
find
not
out.
our right to do if they want to develop it. They're not asking to develop it. They're asking for a variance to turn for a reduced frontage lot. And it is within our purview to say no to that. But if we want to say yes to it, it is also in our purview to put conditions on it.
I'm also looking at this, if this is 2 acres here, and this is the high and dry, how many more 2-acre parcels can they possibly get out back here?
It's not on the table here.
I mean, what is the reality of our concern about a shared driveway? Are we gonna have 2 houses?
What is our concern?
No, what is our concern as a group?
Yeah.
Looking at this parcel, here is 2 acres. That's
This is the
the,
lot that he's building, I'm not having, oh, I see, right here.
This is-
right.
I'm sorry,
So
I've
this is
driven
the whole
all over.
parcel that he owns, is that correct?
this is the whole parcel that he owns, this.
Right, and he wants to build this.
And so
Right
he's
now.
taking, that's 2 acres.
Yeah.
So a pork chop lot has to have 2 acres. And
And it does.
Fine.
there is nothing for him not to break off say that can be another house here, put the frontage down to here, and use a shared driveway here. That's what this gentleman's trying to protect, as he can put the frontage down on Crestview. It's wet, they can't go across Crestview, but they can put it back here.
And how
So
do we have
whether
the
it's a
right to prevent
subdivision
that?
road or a shared
Prevent
driveway to
it.
get into these other hidden lots, I vehemently want to state our objections to the fact that it's really a matter of semantics, a subdivision road or a shared driveway that can get into 2 or 3 homes because the traffic.
Well, subdivision road has its own frontage.
I
And then
understand.
allows lots every 150 feet, every acre. And that's a different ball of wax.
Well, in respect to the fact that traffic will increase.
Can I have a motion to continue the hearing to?
Well, just before we do,
That's your
Cheryl,
preference.
you're saying you will not accept the deed restriction that only talks about a subdivision road?
Are you okay with continuing?
Well, let's see if we have to. If Cheryl will accept the deed restriction that it cannot be used as a subdivision road, then we have agreement. Granted, there are objections to any development of this land, but it's also been acknowledged that if you own the land, you have the right to use it. Traffic, 4 cars a day versus 2 cars a day it's a hard
It could
argument.
be 8
to-
cars a day, because every
Well,
family has
that's
2
one
cars.
every 3 hours.
Well, it's still, you don't, I mean,
No,
that's a lot.
No, I bought a house and somebody built next door, but remember, you built a house next to somebody else's door. If everybody in this town said, I don't want anybody to build next to me because no one would be here. There'd be a
know
lot
what?
of Native Americans living
That's a
here.
certain,
One house,
So-
one driveway is different
Yeah.
than a few houses down. There is a shared driveway back there that has 3 houses, and you'd be surprised. We have a 2-year-old. You'd be surprised how many cars come along Boxborough. It's
That's right.
crazy. And
Yeah, we
they
had to
go-
put down
it's-
a
it's
slope.
Isn't there more than
yeah,
3
we had to
houses
put a
off that
slow
road, though?
thing, yeah.
Isn't there more than 3 houses off that road?
No, it's only 3.
What is
They're
the-
off that
what is the
shared, I
process
believe
for
there's 3.
establishing
and
a
then-
shared
yeah, in the
driveway?
back of the
Is that a
house.
planning board
Yeah,
process?
special permit process with the planning board.
But they can't, if they meet the criteria, they can't turn them down. So what
Because
what
you
he's
remember,
trying
if
to
we do
protect-
allow this, and we say it can't be, because right now, if we disallow it, next week it can come back with one, and yeah, this is going to be a
Right.
subdivision road. So what you're giving up, a lot, there can't be that much development to begin with, you're minimizing it.
So-
You're not gonna be able to eliminate it. You're
So-
saying, okay, I'm gonna accept a little bit of development so that I won't get a lot of development.
Right.
If we say you can't do a little development, they're gonna, okay, we'll go for a big development. So you gotta be a
Right,
little
I
bit
just came,
careful
I was
what
even
you
shocked to
get.
find out, I just came here because we thought that it was gonna be just one driveway, one house, and it was, you know, now
That
to
is
find.
what the proposal is.
Correct, but it's,
But the thing is,
I
he
sense
can't-
that there's
what
someone
Yeah.
else
he's trying to
coming.
protect is,
He's a little.
down here on Crestview, you
Yeah.
don't have to front the same road you have your access off of. You just
Right.
have to have the frontage. So they can divide up from Crestview and put the
Right.
frontage down there and have the access up here. Now, they can only do that with 3 houses, which is maybe the best, quite frankly, the best solution. It may not be one you like,
Right.
but it may be the best solution.
As
Because if we
opposed to
don't,
what?
if we don't, somehow this land's going to get developed.
Okay.
So-
Are you saying that he could never build access off of Crestview, and we'll never see those cars? Is that true?
Depends on the topology of the land.
Yeah, but that was a long time ago.
I'd like to know the
No,
answer to
that's
that,
too,
because I assume that other
I
lots
think
might
what
have
he's
access to
saying is
Crestview.
that,
This is
you know,
what-
if we allow the subdivision deed to go through, like what Cheryl's asking, then it won't.
Oh, you're right.
uh, so-
Yeah, it's the whole parcel.
That's the
Okay,
whole
never
parcel
mind,
a
never
long
mind,
time
never
ago.
mind.
It's, I have a headache now, I'm sorry.
Well, can I just make another statement too? Hammerhead lot is a by right approval.
What's that?
Hammerhead lots are by right approvals. So if you had frontage on a street, you could propose a hammerhead lot anywhere. You know,
Okay.
you don't need a variance, don't need a special permit, it's by right approval. So the only reason we have to come here for a variance is because when those lots were created, when your lot was created in 1956. It proposed, or it left access to the rear portion of the property in the intent that maybe someday there would be a subdivision road down there. We are not proposing that. But I want, the only reason we're here is for the variance because the adjoining lots don't have the required 150 feet of frontage. So that's the only reason why we're here, but a hammerhead lot is not a variance. You don't
I
need a variance.
understand that.
Okay,
I just really, and you may or may not know that the reason we even pursued purchase was because there was a rumor that that driveway was gonna become, for lack of a better word, it's a little bit of a freeway from here to Crestview. That's not true, okay? But now I'm hearing for the first time that it might be a shared driveway because 3 lots are gonna be built, and you're telling me.
I'm not saying-
I should
that.
take
I'm not
No,
saying
it's
that
just
either.
that could
I
eventually.
know, right,
could
exactly. That
happen. But we
potential
can't
exists because
stop-
you can't write that into the deed. is
Well,
what you're
if-
saying.
Okay, but the thing is, they want to develop this land. They're going to figure out how to do it.
Right.
Whether they buy a piece of land that's slightly bigger, that from someone who has more frontage that abuts them further down the road, where they buy it, you could, if we turn this down and tell them to go away, and they eventually could put a whole subdivision back there. This may be.
Right,
Access where?
I'd
Off
be
of
more
Roxborough?
comfortable, honestly, having it having, just like what you said, having small development versus like huge.
Because if you make it, they will find a way. They're going to find a way to develop this land.
Look, I understand, and I also understand, and I mean, it's just a gut, that because you won't accept the fact it's one lot, one driveway, you want to be able to share it, that tells me without a doubt that you're going to put more houses back there and they're going
That
to
is
share a
not,
driveway.
that is not true.
Well, it's not true today, but it might be true next month or 2 years from now, you know.
Or 10 or 20.
Right, exactly, and we're going to be gone by then, okay? I mean, I'm telling you, I care, I mean, I don't care about my kids, but, I know, you're not, but I mean, your kid's going to be playing in the road, and there's going to be, you know, maybe the traffic's going to increase by, I don't know, 50 cars a week, I don't know. The thing is, I personally would feel more comfortable if I knew that it was one house, one lot, one driveway. If you're saying that you're going to grant the variance today because it's going to avoid some potential for some massive subdivision down the road, I don't know if I'm still interested in that. I want to enjoy the man has a right to build, that's fine. That's fine. And you know what, I mean, really, it's fine, but I mean, I also think that people that purchased homes on that road have a right to a certain amount of ability to protest massive construction behind their homes.
They do, but we also have to follow the law.
Understood.
And we have to follow zoning laws and bylaws.
We're
This is-
not approving massive
Well,
construction.
I
It's an 11-acre
hyperbole
parcel,
and I
there's only a
apologize.
certain amount of homes
I
if
know
they
that-
did
but-
every
I get
inch, but there's conservation, I mean, there's conservation issues. But, so, we're back to Cheryl. I think I would say that Mark and Rod and I, is it fair to say that we are
Can
in
we limit
support
it to
of
2?
reaffirming?
Can I get
the-
something here?
Well,
Very
I just want to
very
remind,
fine.
if we do a shared driveway, it's still going to have to go to the planning board.
Yeah, but the
It's
planning
still-
board will have to approve
Yeah,
it. They won't have a choice because it
Well,
will
that's
meet
not true.
it will meet the
for the s-
guidelines.
For the same reason why they're making objections for this, they
No,
can make
because if you
objections
but if you put the frontage down here,
if.
the planning board will have no choice
If.
but to grant that.
I mean, I don't think my client's planning on doing that. I know he's not planning on doing a subdivision road. I can tell you that right now.
No, because it's too wet and it's nasty.
Well, I'm not saying that at all. That's not the case.
Hold on one
You can do, I mean, there's, like you know, you can do a lot of different things. He's not proposing a subdivision road. And to my knowledge, he's not proposing a common driveway. But I don't want to restrict him by doing that. And like I said, that's not what we're here for. We're here for one lot.
Yes.
Would it have, if in the future they wanted to do a common drive or shared drive, would it have to come back and get approval to the planning board?
Absolutely. Absolutely.
Yeah.
But on the other hand, the planning board has to follow the rules and the laws also. And the planning
The rules
board,
for common driveway at that point.
yes, and
Which wouldn't pass here because. I don't
actually, if it's an existing driveway with enough width, and an existing driveway only has to be 20 feet,
Yeah, but
What's for
he
common
is actually
drive?
correct in that statement because
You'd still have to
there's a
have
grade
frontage.
issue out here too.
but what is the width of a minimum width for a
I
common
don't
drive?
know
It's
that.
like
What,
25
40?
feet?
I think
No.
it's wider than that.
No, I think it's only 25.
I'm on
or
a
something.
common driveway. I'm very interested in this because depending on what you do for a variance here, I could redo my lot and get a same variance to build another house.
You wouldn't be before us for a variance, you'd be before the planning board.
Sure.
As much as I can, I'm
Thank-
sorry, but I gotta
No,
do it.
thank
No, but I mean,
Very
at least, I
I don't-
appreciate you taking a kind of a counter step here because you people know the legal end, builders know what they want to do, neighbors have to kind of voice their
And
opinions
people
about
have a
it.
right to build on their own land.
That's fine.
They really do. And they can make a subdivision with, their frontage down on Crestview and come off on a shared driveway. I'd like to be able to restrict that. He's saying no. So then it comes down to, does,
I'd rather have
can we restrict it
I'd rather have a
to
bird in
2?
the hand.
I'd rather not, like I said, I'd be more than happy to restrict it to not being a definitive subdivision road. Cul-de-sac, through road, anything.
Share the driveway.
But I don't want to restrict it to be a shared driveway. And that's just, like I said, my client's not here. But a definitive subdivision road is
I
a,
don't know the ins and outs of shared driveways, so I'm skeptical
I have
about
one
this
right
whole.
next door to me.
I'm skeptical about this whole issue because the remaining parcel has frontage on another road.
It doesn't matter, they can still have to use a shared driveway. For example, there are lots of places where the shared driveway, off Whitcomb, that development off Whitcomb,
Mhm.
they all have their frontage down like here, and yet their road comes in here.
But there's been a planning board revision of those.
Yeah, and they
watersheds.
changed the rules so that there's a factor about the size
Right.
of and the wiggles a lot can have. It has to,
Lot shape,
yeah, I'm sorry, I know just enough to be dangerous.
which
But-
this lot conforms to the current regulations for lot shape, for lot area, for everything for a hammerhead lot.
So-
The
so
bottom
the-
line is they could put a 150-foot lot here and have it come all the way up, abut this house, and have a shared driveway with an easement across
Why
it.
wouldn't they put a driveway from Crestview?
Because it's wet, and
Okay.
it's ledgy, and it's nasty, and that's why it hasn't been built. And-
Okay.
Sorry, I should stop saying it's nasty, it's not
You
nasty.
should, yeah, you shouldn't say
It's
that.
it's difficult to build on.
But we're not here for that, we're here
Right.
for that.
It is a challenge to build on. They could certainly do it.
So getting back to the question at hand, Cheryl, will you approve this if we put in a deed restriction that it cannot be a subdivision? Up or down? If it's up, then we continue
I don't
with the
want to, but I
hearing.
think I should. But I don't want to.
Because even in the original Board of Appeals, they said, essentially, should have read it, I simply repeated it, said, the only reason they need a waiver, but for the curvature of the road created by the access strip by an engineer in 1956. So by a stroke of the pen, all of a sudden we need a waiver. So that's essentially what we're saying, is we're waiving,
Oh,
okay,
you're
somebody
saying,
made
you're
a
saying we
technical
should.
mistake.
You're saying we should approve this because if this came straight, it would be a hammerhead lot.
We
and-
wouldn't need to approve it, it wouldn't be here.
Curvature is
But
related
anyway,
to-
that's the
Because
point.
their land would be a
That's what we
little
have to
bit
look
bigger,
at.
and they'd have 150 feet, is what you're saying.
Right.
And this would have 150 feet.
So we're discussing a technicality and adding provisions that we really don't have to, but we're willing, but he's willing to accept it.
But the curvature was put there so it could be a road.
Exactly, and we're saying it's not going to be a road.
I think that's the very best I can do for you, honestly. And if there were other people here and I'm not here, they wouldn't even do that. So I think right at the moment, my vote's very important because there's only 4 of us and they have to have it unanimous. If this is continued to another day, the vote might be very different. I might be the only person holding out, in which case,
Well, it seems to be you're the only person holding out right now, right? So-
right, but I'm only important.
Well-
And
well-
Maybe, technically, might not even be holding out.
Cheryl has achieved the road issue. You know, we're willing to put a further restriction on the lot about the establishment of a road.
You fought for us and
He
we
needs
appreciate
4,
it,
what I'm
so.
saying is he needs 4 votes. Next month, there'll be more people here. Right now, we're shorthanded. He needs all the votes. Next month, he won't need all the votes.
Only needs 4.
He only needs 4.
How many are there usually?
There's usually 5.
Okay.
Actually, 6.
6.
Yeah, you don't, the 5.
We usually have 5
Five
voting members.
Look, I know, I know you guys are just like everybody else. It's getting late and stuff like that.
Oh, this is early compared to something.
I really.
And remember, we're all volunteers, just trying to do
People are
our
always
best.
before this board
I
because
know.
there's some contention, so don't feel guilty.
I know what you're trying to do, and I know that we as, you know, we're new to Littleton, 2 years.
I grew up in
And-
Littleton, and I'm a real estate broker, and I understand.
Okay, I know, and we had a lawyer investigating all of the possibilities for us, and we opted not to do it because, quite frankly, we didn't know if it was going to retain its buildability. But, 10 years or 20 years from now, but that's beside the point. I guess my husband's concern, who couldn't be here, my concern, and I may speak for my neighbors as well, is that one driveway does not, even if it, thank you, because there was rumor that it was going to be a cut through to Crestview, so that's not on the table anymore. But the fact that it's going to be trafficked by up to maybe 3 homes? And because
There's
the worst
a
case scenario.
speculation, it would have to go through the planning board, you can come to the planning board and.
You would be
It would-
notified of that, and you'd have.
It would be, not necessarily, planning board doesn't
Oh.
notify.
That's a public notice, though. It'd
It's
be
a
the
public notice,
agenda.
but you don't get a postcard.
Yeah,
No,
Unless
planning
it
board
was a-
doesn't.
Yeah, but
Unless it was about
what option would we have if it
The only
if it ever
thing, the
came
only
to
thing
that?
I think I'm gonna be successful doing is to keep it from ever being a road. I don't think I can keep it from ever being a shared driveway.
Really?
I really don't think I can. Because they're right, they could come along and the person on the right, they could offer to give you a little piece of land. Suddenly they're a legal driveway, you have enough frontage, you have 150 feet front, you're really close to 150 feet frontage.
Yeah, I mean, I don't know when the house was built, but I know we're not 150, we might be
Sorry, I
like
don't have
30 or
glasses on.
something.
How much frontage do they have?
130.
I think you do.
They could give you 20 feet of frontage,
Mhm.
and then suddenly they are, by right, a driveway, and can go back there. They're gonna, if there's land back there that's gonna be, that's buildable, they're going to build on it one way or the other probably,
Mhm.
someday.
Mhm.
So I think this is the best we can do for you, is to keep it from becoming make sure that it can only be a driveway, and if it's only a driveway, the most it can have is 3 houses.
Is that the
true?
most a shared driveway can have?
The
or-
most a shared driveway can have, according to our present zoning bylaws, which are fluid, I gotta tell
Right.
you, they're about to change. You should come to the May meeting, because there's a whole bunch of zoning things up there that should be talked about. But I think this is the best we can do for now.
We're, as much as I totally support you,
Yeah,
and
you do.
I feel like this is what, she's, I feel like it's
I-
the
I
best,
understand.
the best.
You don't have to agree with
Well,
that. And
I
you don't
don't
need to
really have
her
any say in
approval.
this. You guys are gonna
I know.
rule.
I know you.
I know I
You guys
don't.
are gonna rule, and,
We
and you know, all I
just
can
know
do-
that we appreciate everything you're doing, and we're okay with that if you put the deed. I am speaking for my husband and I feel like that we're okay as long as you put the deed for no subdivision.
We're volunteers, we like to make abutters and neighbors happy. However, sometimes we can't. And I can't just, they're right, he could give you 20 feet of frontage, and suddenly he has a
Okay.
lot that doesn't even need to be.
Thank you for your input. So, once again, we're gonna try to close
Can
the
we
hearing.
address one more thing?
Yes.
Joyce, they have to go before the Board of Health for, drainage and where
You don't have to go through the Board of
where
Health
do you go for appropriate driveway
grades.
grades and things like that? Who has to approve those?
Well, Roland looks at the issues to see if there should be a driveway plan. I believe probably Jimmy Clyde, the DPW, would make sure that it's a safe driveway. There are no driveway permits required, to my knowledge, in the town of Littleton.
So it would be part of the building permit process?
Correct, it's just like if it was a flat open lot, you wouldn't need a design of a driveway. But common driveways, absolutely, absolutely.
Topographical driveways are not under our purview? Does that make sense?
I don't know that.
It's just not under our,
If it's the law, it's the law.
it's not under our purview. We don't rule on how steep a driveway is, or how, unless they're told by someone else they can't do it and they come to us as an appeal. They're not asking for anything about the pitch of the driveway.
When the original decision said that the engineering design at the time would adequately address drainage and runoff, would be completely contained by culverts and pipes directing the water runoff. And it's more than just him saying that. Obviously, it's gonna be, someone's gonna have to look at the plans, somebody's gonna go out and inspect it and look at it, so.
There's a culvert under the road.
Yeah, well, I'm not sure what the design is going to be, but it should be, yeah.
But under normal construction, all the drainage has to be contained within the lot. So you can't drain surface water, driveway drain, runoff, or anything onto somebody else's property. You're not allowed to do that under any circumstance.
And if it does happen, you should come immediately back to the building inspector. There's a certain number of years that a culvert's in place, and then it sort of
Yeah,
becomes.
I mean, I can only assume that you're gonna put some type of drainage at the top of the driveway, since it does slant down into the lot.
Yeah.
Usually you put it at the bottom, that's where the water goes,
You wouldn't
yeah.
even put it at the top where
Right.
the road is.
So do we need to reference all of this?
I was gonna say, the permit, the application's, already been written up. Pretty much got a copy of that one.
When we do a variance, we have to grant it on specific criteria, usually relating to the topography of the land. And so any decision is usually worked back into this, special consideration. So we would refer to the previous decision.
Can we just reaffirm the previous decision?
Well, that would be incorporated into, the findings, so. Yes.
Approving it as you're stating it now, what would have to happen if they did turn it into a shared driveway at that point? Afterwards?
Well, in that case, you would have to have an engineering.
Absolutely.
Yeah, it would have to conform to
There's more.
stricter standards than, just a single residential driveway.
I don't know where shared drive, do you know what shared driveways are?
I don't, but I know they have to be engineered, they have to be certain turning radiuses that you have to maintain, certain grades, certain widths. Depending upon the length, you have to have pull-offs for if there's
Emergency,
traffic coming,
yeah.
emergency vehicles.
So given this variance doesn't automatically just say that you could turn it into a shared driveway, there's subsequent requirements to make it a shared driveway.
The variance before us is for this one lot, and the rest is speculation.
Yes. Just wondering what the process is looking forward.
Yeah,
It's more than likely it's gonna come.
according to our zoning bylaws. And the fact that this is, has been pointed out to me several times, that if they gave 20 feet of frontage, which they have extra, to the neighbor, then they wouldn't even have to be here.
Okay, may I have a motion to close the hearing?
With the deed restriction to.
Well, we're just
Oh, no,
closing
this
the
is just
hearing.
We're
closing.
closing the hearing. We
Oh,
will
We get to
continue
talk
to
about this
deliberate.
again.
Yeah.
No, I don't know.
It just, once
And
we
you
close
can
the
leave or you
hearing,
can-
they
you can
can't,
stay.
you guys can't say anything.
Oh,
Yeah.
We can't ask
Yeah.
any more
So
questions.
we've had all the input that we need from the
He can't,
relevant.
he can't answer any more questions.
I think
A little bit like
you've
we're
made your
already going
position
into
clear.
another room discussing it.
We've heard from interested parties, so, Mark, would you,
Well, I need to know if Cheryl
Go ahead and close it.
is in agree, okay, I'll take that as a yes. I make a motion that we close the hearing on case, actually, you don't have a case number on this, it's blank at the top.
yes, it is.
Oh, I'm
It's
sorry.
885, I think.
885, okay.
Do I have a second?
Okay.
The hearing is closed. All in favor?
Aye.
Hearing is closed. Now, I think we do want to deliberate now. I think we've sort of deliberated during the, during the hearing. And what I would like to do is construct a decision that refers to the previous decision and the further restriction,
A deed
a
restriction.
deed restriction for the subdivision road.
Cannot be a subdivision road.
That it would preclude, that would be not allowed. And the concern is that the physical dimensions of the access would otherwise allow it. So that's why you are, okay.
Could certainly be grandfathered in.
We've heard from abutters. I personally feel we have some obligation to uphold this previous decision, since the owner may have, notwithstanding the building inspector's decision, the owner may have assumed all these years that this lot existed. So, Rod, any comments?
Yeah, just to go on the record before I vote in the affirmative. Number one, I'm still very skeptical that a variance is even required here, since they have a valid N&R and an A&R. And secondly, I am opposed to any deed restriction, because I don't think it's appropriate, and I don't think we really have the right to do that. Just want to make sure it's in the records when
So you're
Shelley
not going
looks
to
at
vote
this.
on it if I put it?
No, I said it before I
He-
vote in the affirmative.
He's going to
I wanna
vote for
put
it,
that
but
in
he
the record.
opposes it. So that's fine.
Well, then let's just oppose the whole damn thing. I mean,
No,
enough.
he's opposing the statement concerning.
Excuse my
Mark.
language, I'm sorry.
Do you have any comments?
No, I think we've thoroughly discussed it.
Cheryl, and you've aired your concerns. So, may I have a motion?
Well, should we make sure we get a adequate deed restriction write-up that is within our knowledge of that is,
I think we can just say that we will grant this contingent upon a deed restriction that allows no more, for it to never be more than a shared driveway, or it can never be a subdivision road, or it can never be.
You had specific
more than-
language.
How about
Am I
more
allowed
than
to
a
speak?
driveway?
Can we just say not a definitive subdivision road? Subdivision, I mean, because like I said, a road, if we create a road, it's got to go through the definitive subdivision process. That's.
I don't want to say definitive, I just want to say.
Well, that's what
Well,
Mass
that's-
General
that's
bylaw-
legal,
That's a legal
that's my
term.
concern. We've got to make
Yeah.
sure it's a legally
Correct. That's what
binding
Mass General
restriction,
bylaw-
that it can't be
It's what the-
interpreted
the
to mean
planning
something
board-
else.
They always have these definitive subdivision.
Yeah, keep it simple like that.
Can we say it will never be more than a driveway? And there's nothing to keep it from being a shared driveway then? I'm just worried that, how
Well, then
many,
what's the
how many
point?
different subdivision, there's, what, are there different kinds of subdivision roads?
A definitive subdivision is a process through Mass General bylaw, through the planning board, to create road frontage. Whenever you need to create road frontage, you go through a definitive subdivision.
So that you cannot have a subdivision without it being definitive?
Well, it's a process. That's the term that's used in Mass General bylaw,
So
definitive
there's no other
subdivision.
there's no other process or way of,
No.
I mean, I feel like
To
I
create
feel like
road
I've been
frontage.
chasing a cat around
I
here.
think you have, because to create road frontage, the bylaw has, I mean, you guys deal with the zoning bylaws, but there's also the subdivision control law. Subdivision control law talks about creating road frontage through the definitive subdivision process. That's a public hearing, that's extensive design, drainage, a number of different things.
Is there a grandfathered subdivision process that, is there a way to become a subdivision without it being called a definitive subdivision?
That's the term that I've always used since '86, so, and that, I believe that's the term
I don't
that
want to
the
say you
local
can't have a
bylaws-
black cat and suddenly find out there's a gray one there. Does
Well,
that make sense?
If you go through the subdivision control law, they talk about definitive subdivisions. And they have criteria for design, permitting process. You have to go in with a preliminary subdivision before. You don't have to, but it's suggested. So it is a process. So the term definitive subdivision is in the Littleton subdivision regulations. It's in there. So that's
So
consistent
you
with
should
not
have
only
no
Littleton.
objection to it saying more general term of the subdivision road.
I don't know if I agree with that. Why not use the precise term?
Because I think that I guess what I'm concerned about is there are more,
You have to go through this process to establish.
okay, if you say, because he's not saying that there aren't other processes that you can't get a subdivision through.
No, he is saying that.
Yeah, I think I did.
He did.
You
is
are saying that?
that, yeah.
There's no way for this to become a subdivision without it being a definitive subdivision. Okay, that's
Yeah.
fine then. I just don't want to say no dogs and find out when I mean no pets, kind of thing.
Okay.
Does that make sense?
Yes.
Um,
I agree, and that's fine.
So we will place a deed restriction on this property that it may not be used to, how do we put this? It not be used to create a
The drive
definitive.
will not become a definitive subdivision.
A subdivision road.
Right.
Just say it won't become a subdivision road.
Or become a road as part of a definitive subdivision.
Yeah, that's good too.
Yeah, I like that.
Do you think
Okay.
that covers all the bases?
Yeah, cannot become a road.
Cannot become a road.
As part of a
As part of it.
definitive subdivision. I don't know what other kind of road there would be, but.
Because roads are a legal term, so to speak, just as driveways are. But, yeah.
Do I have
The space.
a second?
So we're basically saying we're reaffirming the original
Yes.
with this.
We will
addition.
incorporate the previous decision into our findings, along with a deed restriction, so that do we want to call it the pork chop, or
The
the?
access.
The access,
to
the
Boxborough.
access will not
To the
become
access to
a
Boxborough
road as
Road.
part of
Lot
a
8.
definitive the access to Boxborough Road, that's good too.
Do you have any access anywhere else?
No.
No, well, I think you should be specific and call it Lot 8. because that's what the plan
Okay,
shows.
the access to Lot 8.
Correct.
Okay. The access to Lot 8 will not become a road as part of a definitive subdivision.
So, so
And we can refer to Lot 8 refer to the drawing.
we can
Yeah,
have the
just
town
attach it
attorney
to
draw
it.
up the deed restriction. That'll take him 5 minutes.
Okay, so do I have so we have a motion?
So the motion is, let's read the motion.
Well, the motion is to grant a variance incorporating the findings from the previous
The variance granted
hearing in 1990, the date of 1995, with the further provision that the access to Lot 8 will be deed restricted so that it will not become a road as part of a definitive subdivision.
No, the word definitive still bother me. I just wanted to say it will not become a road as part of a subdivision.
That's what we just added the word definitive, which is a term of use,
Okay, but why do we need it?
because it's the term of use.
Okay.
No, as you said, and let's have town council actually write it up so that way,
So, yeah, okay.
that'll be a check on that.
Do I have a second?
I'll second that.
In favor?
Aye.
Aye.
Opposed? None. Okay, so this is granted with the further proviso that we've been discussing.
So we need to get the town
And,
council to draw up the
and
restriction.
in the future, I don't know the ins and outs of shared driveways, but if there is such a proposal, then you need to, go before the planning board and state this.
Thank you for your
Okay.
time.
You won't get notification.
How do we find out? We have to keep our eye on the local paper?
Or you could ask,
Well, it depends on whether the planning board does it in a meeting or a public hearing. A public hearing, they have to do the same kind of notification.
they don't notify butters, they just do a public
I
notification.
think
of
any
neighbors.
public hearing requires notification of the butters.
No.
I think so.
We were coming here for the Pine Road, the Oak Road hearing. We were sent the wrong card.
I know,
wrong
so we can talk,
address.
so come forward, we'll tell you what we did and what they're proposing.
Thank you all
And
very
I'm
much.
sorry you ended up in the
Yeah,
wrong
it's been
place,
very
I'm sorry you
educational.
folks.
Thank you.
And at
Thank
the
you.
wrong place, I'm
That's why I
sorry I
joined the
couldn't
board.
keep doing anything for you.
Cheaper than going to the movies.
Should we adjourn before we get into it with these folks?
Cheryl,
Yeah.
thank you so much.
Yeah, move we adjourn.
Actually, all you guys, I've served on a baseball board for years, and I know everyone comes forward and bitches about everything that's wrong. Thank you guys for volunteering. to do it.
Thank you.
I move we adjourn.
So the matter before us.
Adjourn first?
Should we adjourn?
Yeah, well, we can have this
Okay.
informal discussion, but the matter before us was to allow a special permit for an in-law apartment. So essentially, the house is coming down and they're building a house that will have an in-law apartment in it. So the only thing in front of us, there are no other variances required. It can be done as of right. The only thing that's required is that they come before us to get approval for the in-law apartment, and her parents were here with them. And then every 3 years, they come before us to reestablish the accessory dwelling special permit. It's called an accessory. That's a Board of Health, issue. There is a septic plan that they submitted, but that's not our.
There is a septic system in place.
They have 3 bedrooms
Yeah.
now, and they will still have 3 bedrooms. So they're not increasing their septic flow.
They have 3 bathrooms. I know that doesn't.
Well, bathrooms doesn't matter.
Bathrooms don't
Yeah.
count.
Yeah.
It's,
Bedrooms,
and,
yeah.
it doesn't even count whether rooms have closets anymore or anything like that. So they're going from 3 bedrooms to 3 bedrooms, so their septic system may be grandfathered. They are within the bounds of the required zoning for their setbacks. The only thing they were asking was our permission, my apologies.
Which we routinely grant unless there's something that's we're,
Unless we don't believe that there's
Yeah.
relatives involved, or we don't
Unless
believe
it-
that.
Family member that lives.
well, it's
Well,
defined as a
dependency.
functional dependency, so it could be for a caregiver, it could be for, we're pretty broad. We are allowed to take into consideration, we have to take into consideration parking, but that's pretty much it,
So they're building 2 garages.
yes.
One on each side, one a
Yeah.
2-car, one a 1-car.
We are, under the bylaw, we're not allowed to comment on the look of it, which I would have.
Yeah.
How does that all go?
That's can do it as of right. I mean, anyone can build
According
whatever they
to our-
want,
to our
as long as
current
they
Get a
meet
building
the
permit.
dimensional requirements of the,
So how far do you have to be from your property line?
It's within the setback,
Yeah,
so there's no
15
problem.
So
feet.
15 feet on the side,
So it's
30
like
feet on the
7.
front.
well, I thought the same thing at 17.
Oh, it's 17.
Yeah.
And this will be, this will be established, there'll be a certified plot plan, they can't get a building permit until, we don't, all we did is give them the permission to have an in-law apartment.
Right.
Everything else is handled by the building inspector, the zoning
So it's the
officer.
zoning.
Yeah.
So let me point something out to you folks. There is a bylaw coming up on May's meeting that would allow accessory buildings in every house in Littleton to have an accessory building by right and to be able to rent it out, and as long as it's owner occupied, it basically turns every house in Littleton into a potential 2-family without the fire codes that 2 families have to have.
Or
2 fam-
hearings or, neighborhood
and
input or
access,
whatever.
and the zoning bylaw that's coming before us in May, show up the town meeting, because that could turn, it even bypasses all the standard fire codes, with like firewalls and extra access. Show up at town meeting and educate yourselves on this bylaw, because otherwise you could be surrounded by 2 families.
I'm going to be.
Well, you're gonna have one on one side of you.
Are you in a?
Yeah, we're right on the next side, on the fence,
Okay.
on the other side of the fence. Do you know, by any chance, is this a slab?
I don't know.
I think she's doing a basement. I could be
Okay.
wrong.
Yeah, it sounded like a modular home.
Yeah,
She did say
slab,
Crawl space or
I mean,
something.
mine-
Show me the plan, is there a stair shown,
There's a
Jermaine?
stair, but I can't tell whether,
it goes
Yeah,
up and
that
down.
would,
It's
that
an
would be down,
accessory
that would be an access to a
building,
basement. Yeah.
so there has to be what they call a functional dependency between who's living in there and the rest of the home. as it's
There is
described
now.
earlier. And they have
After
to.
May.
Well, that's, yeah. And then every 3 years, they have to file again that, yeah, this continues. Once that functional dependency no longer continues, then they have no right to have somebody else living in there.
They can't rent it
If,
out.
once their parents pass on, they can't say, oh, we're gonna rent it out. That's
I
not
don't know
allowed.
how to turn it out.
Under the current law.
Under the current law, yeah.
If what the zoning board is proposing
I
in
wanna-
May,
Because this is being filmed, I want to emphasize that
Oh,
we're,
that's interesting.
the hearing is over, we're just having a discussion because of the mix-up with the room.
yeah, we've already made a decision.
Yeah.
And quite frankly, it wasn't a decision that any input would have
No,
changed.
there would
no,
have,
right.
I'm sorry, I'm
Okay.
sorry you
No,
missed,
still, it's
I
good to know.
apologize that you missed the discussion though, and missed meeting the people, and they seemed like very nice elderly folks that said they would go to town meetings.
well, I feel better knowing it's 17 feet.
and we,
not
we,
seven.
we because of the project across the street, we recognized all the neighbors who were here who'd shown up for those meetings.
Oh, that's, yeah.
So you can go online and see what was said and done.
Okay?
Thank you very much.
Motion to adjourn?
Yes.
I put a
Oh, I
motion
thought,
in
I
a
thought
while
we
ago.
already had, yeah. I thought-
Second that motion.
I thought we had adjourned. Meeting is adjourned.
Okay, so that is the switch.